Ms. Keller.
May it please the court, counsel. Nicole Keller on behalf of the appellant Tristan Derby. Thank you for the opportunity to come and speak to you today about this case. This case stems from a birth injury suffered by Tristan Derby in 2007. He's 12 years old now. During his birth, his shoulder became stuck on his mother's pubic bone. This is known as a shoulder dystocia. It's a medical emergency. When this occurs, the delivery team typically has about 6 minutes to deliver the baby before you start risking injury to the brain injury or possible death to the baby. Shoulder dystocia can typically be resolved without causing injury to the baby if the delivery team engages in a series of maneuvers that move from less invasive to more invasive, which could culminate even in breaking the clavicle of the baby, because that's seen as preferable. That will heal without a permanent injury. Whereas if the baby is delivered by traction, by simply being pulled out, that damages the nerve and can cause permanent injury to the arm. That's what happened in this case. Tristan suffered a permanent injury to his arm because of damage to the nerves in his neck. During discovery, we learned that Dr. Widmer, who was the head of the delivery team, was not familiar with some of these maneuvers, particularly some of the fetal maneuvers, which are the more invasive maneuvers that come later on in the process. You start off with maternal maneuvers applied to the body of the mother. Those are less invasive, and then you move on to the more invasive fetal maneuvers. We learned in discovery that Dr. Widmer was not familiar with some of these maneuvers. During the delivery, it was recognized that Tristan's shoulder was stuck. Then what should have happened is the delivery team should have instructed her to stop pushing at this time. There was no instruction to stop pushing. Instead, the nurses proceeded to apply the two maternal maneuvers improperly. We have the maternal maneuvers take place. One is McRoberts maneuver, where you lift the legs of the mother up towards her body. The other is suprapubic pressure, where you use your hand to try to push the shoulder down under the bone. They were executed. They were not executed properly. Another thing that was going on at this time is Dr. Widmer mistakenly diagnosed.
Didn't the attorneys for the doctors say they were executed properly and they were not a problem? I mean, you had a battle of the experts in this case. Absolutely
right, Your Honor. Yes, there was evidence from both Dr. Widmer and his experts that the maneuver and experts for the hospital that the maneuvers were applied properly.
So isn't it just a jury question? You say it was improper and they say it wasn't, and you guess you didn't win.
Right. I mean, it is a question for the jury to decide whether the maneuvers were applied properly. That, I think, hatchets me a little bit forward to the problems with the jury instructions.
Before you go there, I want to ask you a question about what Justice Wiggins just said. If we have an expert saying that the procedure was done correctly on the maternal, am I correct that I think even your own expert testified that the protocol is, let's try these maternal moves first. If those are unsuccessful, then we go to the fetal moves. Is that correct?
That's correct, yes.
So if one expert says the maternal moves were done correctly and the baby was born, if they were done correctly, I know you don't want to agree with me on that one, but if they were done correctly, there's no reason to go to the next type of procedure, correct?
Sure, I understand the question that you're asking. If the maternal maneuvers are performed, that's one of the arguments that the defendants make, that we had requested a jury instruction on Dr. Widmer's total failure to perform any of the fetal maneuvers. When the maternal maneuvers were unsuccessful to release the shoulder, he simply pulled the baby out, applied excessive traction, and pulled him out.
You could have tried this case on one specification of negligence, that the doctor failed to perform the proper delivery techniques after the baby was stuck in the birth canal. And you could have argued every one of these as parts of that. I mean, you didn't need every specification. And, I mean, I used to try these things, and you never really, every little theory of your case. As long as you have the broad specification, you could argue whatever you want. So why is it error not to give those specifications when, in fact, you did argue all that stuff in your final arguments?
I think the case law is clear, and the parties don't agree that the case law is undisputed, that we are entitled to our separate specifications of negligence. It's particularly important in a medical malpractice case where the issues are complicated. There are multiple different errors here. We requested instructions on the different breaches that occurred. The jury, we have a right under the case law to have the jury read that instruction and think about it. Did this occur?
And I agree the case law seems to say that. But as I read your brief, which, by the way, was excellent, I thought, it seemed to me you wanted 11 specifications. You got 3. But of the 11, looking at them, some of them were hastily and without due care. They were sort of kind of generic and, were really not so much specifications as kind of restatements of the overall claim. And lining it up, it looks like you got just about everything you asked for, except maybe the issue about not telling the mother to stop pushing. And there, I'm not sure that there was expert testimony to support that specification. Am I missing something? I know I'm asking a lot at once.
Sure, there's a lot going on here. I think originally had 11. We had a conference. The judge asked us to narrow them down. We came back with 6. We offered 6. We ended up with 2. The problem with the biggest one that we did not get was the instruction that was given never allowed the jury to consider, did Dr. Widmer, was he negligent in his failure to perform the fetal maneuvers, which I think, Your Honor, goes back to your question somewhat. He didn't know the fetal maneuvers, did not perform them, didn't even try. They argue that because the baby was born, he didn't ever need to perform those maneuvers. But the baby was born with an injury. If the fetal maneuvers would have been performed successfully, he, in most cases, can be delivered atraumatically. The instructions that were given never gave the jury the opportunity to think about, should Dr. Widmer have done those fetal maneuvers? The next instruction that was prejudicial was the failure to tell the mother to stop pushing. Dr. Dubois, expert, testified that when you notice that the shoulder is stuck, you stop the pushing. Dr. Boyle, expert, testified that the force of the mother pushing can cause the injury. This is separate from the performance of the maneuvers. It happens earlier in time. It happens when the shoulder is stuck. Stop pushing.
But that baby's got to be born. I loved it when I think that's something the judge said is I think everybody would agree eventually mom has to push again. So that seemed like a pretty obvious reason why there was testimony, I think, by defense's attorneys or experts that pushing is intermittent, isn't it?
It is, absolutely. The shoulder becomes stuck. Instruction, stop pushing. Proper employment of maneuver. An attempt to release the shoulder. Instruction again, start pushing. Absolutely, but and some of that pushing is taking place as the maneuvers are being attempted.
So why couldn't the jury consider Dr. Widmer's failure to perform fetal maneuvers in the instructions that were given? So one of the instructions is applying improper traction in an effort to deliver the baby. And I assume an argument could be made that it's improper to apply traction if the protocol calls for the application or the performance of fetal maneuvers. Likewise, sub A says failing to direct or coordinate proper maneuvers. So,
sub A, failing to direct or coordinate proper maneuvers, goes to Dr. Widmer's obligation to observe what the nurses, direct the nurses to perform McRoberts and suprapubic pressure, observe their performance of that, observe that they're not doing it properly, and correct them to try those maneuvers properly.
Didn't you argue that she should have stopped pushing because it was improper under the specifications given in your final argument?
I believe that that's right. We could have argued and did argue that, but I think that we're entitled to have those where we have
the judge is not required to give the theme of your case. I mean, to make your case more solid than the other person's case. It's just to give the general outline and allow you as an attorney to argue what your experts talked about. I mean, unless I'm wrong on that.
Well, I think that there is case law that says that their court does have an obligation to present our theory of the case so that the jury gives it due consideration. And I'd like to, excuse me, go on.
So your argument is that the specification failure to direct or coordinate proper maneuvers would not have told the jury that of the possibility that he failed to perform maneuvers. Is that the distinction you're drawing?
That's the distinction, Your Honor. I also think that the failure to give any kind of instruction on the issue of bradycardia was very prejudicial. Dr. Widmer testified that he interpreted Tristan to be in fetal distress, and that because the baby is because in his estimation the baby's in fetal distress, we have to do this quickly, or we're going to have a brain injury, we're going to have a dead baby. That's a very persuasive argument for Dr. Widmer to make to the jury, that this baby's in fetal distress. There was significant evidence offered at trial that the baby wasn't in fetal distress, that the heart rate, this was both from fact witnesses and from expert witnesses. There was expert testimony that because of the existence of fetal distress, which is disputed, the delivery had to happen quickly, that because of the diagnosis of bradycardia, we delivered this baby very quickly. The standard of care allows, or in a typical case, you would have 6 minutes to perform the maneuvers and deliver the baby before you have an escalated emergency situation. This baby was delivered in 1 minute to 1 minute and 35 seconds. We believe that if in fact Dr. Widmer believed the baby was in fetal distress, that was a misdiagnosis that led to a rush delivery that led to the injury. That is a separate error that the jury had no opportunity to consider under these instructions.
I'd like to move you to one of your other issues, unless you're ready to move to an issue.
Yes, I see I'm running low on time. Thank you, Your Honor. So I would like to briefly address Dr. Widmer's kind of muddled treatment as an expert in this case. Dr. Widmer, he's obviously a treating physician. He's a party. He was designated as an expert, and we were given a summary of his the topics that he was going to opine about, which did include standard of care in the summary, but he was given no report. After he was designated and we were advised that he may opine on the standard of care, we requested his deposition to redepose him to understand his opinions. That was denied. We filed a motion in limine asking that he not be allowed to opine on the standard of care, because I believe that under the existing case law, unless you provide a report, in most cases you are not allowed to opine on the standard of care, because standard of care is typically not arrived at during the course of treatment. Dr. Widmer was allowed to opine on the standard of care, which I think was inappropriate because he did not provide a report. Now, there is no exception under the existing law for a party, that if you're a party, you can opine on the standard of care. I don't think that exists. I think he didn't report. We didn't get to depose him. He shouldn't have opined on standard of care. It is only one question. Dr. Widmer, did you believe that you satisfied the standard of care? Yes, I do. Now, maybe you'll find that that's not prejudicial because another expert testified the standard of care was satisfied. But what happened then is that we were not allowed to examine him on his training and experience. The evidence showed that Dr. Widmer did not have very much education in obstetrics. It was a small percentage of his practice. He was not familiar with these fetal maneuvers, and yet he was allowed to opine on the standard of care. That's persuasive to the jury to hear a doctor say, yes, the standard of care was satisfied, and we were denied that is prejudicial.
Yeah, I would probably draw a distinction between training/experience and continuing medical education hours. If they're analogous to continuing legal education hours, what classes I've taken for CLE bears only the remotest relationship to the areas that I think I'm the most competent in law. And so, I can see the argument that the CME hours are not very relevant. What else were you not allowed to go into?
I think that it wasn't just limited to asking about his CME records. I don't think that we were allowed to ask him about his training and experience. He did testify during his deposition that he was unfamiliar with some of the maneuvers, which the video was shown.
You got to present that to the jury.
That was presented to the jury, but it did not go into his education or training because at that time when we deposed him, he had not been designated as an expert. I'd like to very briefly just address the birth video.
I want to ask one more question about on the topic that Justice Mansfield just visited with you about regarding the CMEs. And I don't know for sure. I'm not a doctor, but I am a lawyer, and I'm putting on a training in a couple weeks in Harlan, and it's based on juvenile. It's through our district, and there's going to be lawyers there who do probate. There's going to be lawyers who do personal injury. There are people who get desperate for hours at the last minute. Are doctors that way too? Do they have deadlines with their hours, and perhaps they take classes that are convenient in geography and time?
Sure. There are requirements for board-certified doctors, and then there's other requirements for different bodies that they may belong to, just like with lawyers. I don't know, and I don't think there's any evidence in the record, but I would assume that what you're saying is true, that they take classes that interest them or that are convenient for their schedule. But that doesn't get rid of their obligation to be educated in the areas that they practice. They do have that obligation, and it's part of the negligence standard that they bring to the table, the learning and experience that a typical person would bring to the table if you're going to do that. Dr. Widmer was a general practice doctor. He delivered babies 5 to 10% of his practice. He had an obligation to know what he was doing and to know about the maneuvers that could have prevented this injury, and the fact is that he didn't. I see that I'm out of time. Thank you very much.
Ms. Keller, thank you as well. Ms. Schiltz?
May it please the court. My name is Mikkie Schiltz, and I'm here representing Dr. Widmer and then his practice, family medicine. Nancy Penner represents the hospital, and unless you have questions specifically for her, I think I will be the only one that will be speaking today. I'm going to start backwards from where Ms. Keller started, since that's where we all ended, with regard to what Dr. Widmer should have been allowed to testify to and wasn't allowed to be testifying to. In his deposition, which was shown by plaintiff in plaintiff's case in chief, he was deposed and testified with regard to his experience on the maneuvers. That's at pages 487 to 88, 491, 500, 517. He was asked about his experience in those maneuvers, and he testified to those. In addition, he was asked about various standards of care at pages 494, 517, 536 through 37. He was asked about his training, and I can give you those pages as well. All of these were asked of him. The only thing that the actual court excluded was the CME evidence. I believe that the plaintiff, it's our argument that they've waived this. If they wanted to impeach him as a witness, they would have done so when he was called live at trial. That was during the defense's case in chief. There were zero questions, no questions in the brief that were pointed out that the plaintiff sought to ask, that he was not allowed to ask, that was related to the training or the evidence. There were no questions about the CME evidence that were asked of Dr. Widmer or as part of the offer of proof. In fact, there was also no evidence of what a family practice medicine physician must do with regard to CME credits, what types of classes they should take. No expert testified to that. There was no prejudice to the plaintiff. The plaintiff did not preserve this error. And I would also point out, despite what Ms. Keller said, there is case law as to what treating physicians must disclose as part of their obligations under 1.508. Hansen and Carson make very clear that treating physicians do not need to do a report. They do not need to send reports when the opinions that they are expressing are opinions that they formed while they were treating the patient. That's exactly what happened here. And when you read through Dr.
But a
Widmer's
standard of care isn't an opinion you would reach while treating a patient. I mean, you don't, when you treat a patient, the doctor says, and I complied with the standard of care.
No, but they certainly are contemplating that, their standard of care of what they need to do sequentially. So they are thinking about those things as they are practicing medicine. And all of these opinions were disclosed ahead of time. There is in our expert designation that he is expected to testify with regard to the standard of care.
Did the doctor testify in his deposition that was eventually shown, or even if it wasn't shown, that he thought he did everything proper under the circumstances?
I don't think he used exactly those words, and you'd have to read a lot of it. He talks a lot about were the maneuvers performed correctly, the McRoberts and the suprapubic pressure. He says yes. He's asked about the traction. Did you perform that appropriately? I believe I gave gentle traction, is what he says in his deposition, which was shown to the jury. Those are essentially what the standard of care questions were. So yes, I believe he did testify to the standard of care.
I want to move to another topic, talking about the videos and things. It kind of makes me shake my head. Why did the defense have such a hard time with letting that video into evidence if it was a video they'd already seen and you guys got to have snapshots of it? I believe 10 screens or 10 shots. I'm just trying to figure out. It reminds me of maybe one party saying, I want one sentence out of this transcript into evidence, and the other party says, I want the whole thing in if you're going to have a sentence. Why? I don't understand that fight.
I would have to go back to read the transcript as to what was going back to the jury. As I recall it, Your Honor, it wasn't really the defense that said, we don't want the jury to see this video anymore. I think we just said, and the court brought that up on his own, we've seen it enough. I mean, I didn't count. It would take me hours to go through the transcript to count how many times this video was shown to the jury, but I'll bet it was about 15 to 20 times.
So do you think that's an abuse of discretion argument that the judge allowed?
Yeah.
Refused to let it go back?
Exactly, and it was allowed. They did go see it one time.
But it wasn't unlimited.
It was not unlimited, but they didn't ask for it anymore. I don't think he said if they had come to him again and asked for it again for a specific purpose, we don't know what would have happened.
But when exhibits are in the jury room, who knows how many times they look at it. But if they got to go out and ask for it, they might only look at it once.
And part of the reason that they had to ask for it was twofold, as I recall, is that whatever TV and DVD player they had in the jury room, the judge thought it was much better in the courtroom. They had a bigger TV or a better DVD player. I recall him saying that on the record as well. So, yeah, absolutely. When you look at the case law on the video issue, it is an abuse of discretion. You have to look at all of the facts and circumstances. And basically, the court has found that there's no error by limiting it to one time. There's no error to having it multiple times. It depends on the facts and circumstances in the case. And in this case, similar to some of the cases that we cited, the jury had already seen this video multiple times, not just straight through for the 20 minutes of the video, but also starting and stopping it at various spots that the plaintiff's counsel wanted to question various experts on.
Can you address the argument that the jury wasn't instructed or allowed to consider Dr. Widmer's personal failure to perform maneuvers because specification of negligence A really deals with direction and coordination of others and not his own actual actions during the delivery?
I do actually think that it's subsumed in A and B. When you look at the record of what was argued by counsel for plaintiff, the failing to direct or coordinate proper maneuvers is almost exactly what plaintiff's counsel asked for in his specifications of negligence. Granted, he had other ones. The word and the failure to use wasn't actually brought up to the court specifically when we were arguing these instructions. And when you look at what the evidence was, I agree with Justice Wiggins.
I thought proposed instruction 21, correct me if I'm wrong, says failure to properly and effectively use maternal and fetal maneuvers. And that's referring to Widmer directly. Is that correct?
Right. And what the judge did before he came in had come up with and we worked on them. We worked through some of those. But looking at that instruction alone, just simply that instruction, it would be confusing to the jury because it was undisputed that Dr. Widmer did not use maternal maneuvers at all. He did not use any fetal maneuvers at all. And no expert, although Dr. DeBow kind of references you need to go on to other maneuvers, he never said that any of those maneuvers or failure to use those other maneuvers actually caused the injury. What Dr. DeBow testified to, and said it several times, that his main criticism in this case was the fact that there was excessive traction. That's what he testified to. Downward excessive traction is what he believed caused Tristan's injury in this case. So I think and I'm not sure what number it was, I call it the fourth one, the failure to use, I think it was part of in failing to direct or coordinate proper maneuvers, and by applying excessive or improper traction. I think they are
I
included
suppose
together.
one way to coordinate is to do it yourself. Is that the
Right,
theory?
absolutely.
Can I change subjects for a second?
Sure.
Was the slow fetal heart rate, was that a contentious issue? I mean, Dr. Widmer, your client said it was, and I had an emergency right there, and I have to get this baby out, and they're claiming it wasn't. But did anybody testify that him doing it under those circumstances was negligent, not coming to that conclusion?
No, Your Honor. In fact, what Dr. DeBow said, both in direct testimony and when I cross-examined
DeBow is
him.
who? That's the defendant's?
No,
plaintiff's
DeBow was the plaintiff's expert.
Okay.
What he said is he cannot say for certain if there was bradycardia. He cannot look at the records and determine if there was bradycardia. These are page 116, 122. He also testified that he did hear the heart rate in the 70s on the video, and that's at page 130. There's no expert, Dr. DeBow or otherwise, ever testified that Tristan was not experiencing bradycardia, that this was not a medical emergency. And was this a big deal at trial? From plaintiff's standpoint, yes. Mr. Goodman certainly argued this extensively, but his expert did not. Similarly to the fact that his expert also did not testify clearly that you needed to stop pushing on that other specification. The person who testified actually was Mr. Goodman to that question, not Dr. DeBow, who was the expert in this case. We would ask that this case, that the court affirm this. We think the case law and jury instructions shows that the court considers this based upon an abuse of discretion. And if there's any error, it has to be to a constitutional magnitude. The court has to clearly look at all of the facts and circumstances of the case. What did all of these experts, these fighting experts, say? What was the heart of the case? What was the heart of the issue? Dr. DeBow said it, and then Judge Cruz actually used that instruction almost directly from what Dr. DeBow said was his main criticism. There was no prejudice to the plaintiff in this case. The case law is clear that you're not entitled to your specific specifications. A plaintiff doesn't get their specifications, and if you look at the record in this case, the defense certainly did not get their specifications. Ours were basically thrown out by the judge. We didn't get anything hardly in there that the defense asked for. And now the plaintiff wants to quibble about a word here and a word there that was not provided. The law is clear. You're not supposed to emphasize anything within a plaintiff's case or a party's case.
You know the record better than I do, but does the expert testimony show that bradycardia, or maybe not even bradycardia, that fetal distress is often experienced by a baby who has this shoulder thing going on?
I don't think it says that specifically, because the fetal distress that Dr. Widmer was concerned about was fetal distress that happened before the shoulder dystocia, which is why he thought shoulder dystocia is obviously a medical emergency, but it's also important to deliver the baby quickly if they're showing signs of fetal distress beforehand. That's what the testimony was about. That's what the question about fetal distress was, leading up to the shoulder dystocia.
And the 6-minute number that I think both parties have talked about is regarding once they realize the shoulder problem.
Correct. And I think the testimony is 6 minutes is on the outside of what you want to do once the head is delivered, whether there's shoulder dystocia or not. That's their concern. There's compression at that point. If there's been fetal distress before that, that time could be less before there's concerns for the baby.
6 minutes is a guideline, but if there's fetal distress, you have to make a decision to apply excess traction to get the baby out or do an immediate C-section. I mean, those are your choices.
Those are your choices. Those are your choices.
And you don't have much of a choice when the baby starts going down the birth canal, do you?
Not a lot of choices. Any other questions? I thank you for your time.
Thank you as well. Ms. Keller, rebuttal?
Thank you. I'd like to address the defendant's position that the case law is clear that there's no abuse of discretion in failing to give the birth video. I think that the cases cited by the defendants and the way they discuss them ignores a distinction between some evidence that may be testimonial, such as statements or videotaped depositions, that where if we allowed a juror to have a video of one deposition that happens to be on video, that might overemphasize that testimony over testimony where they don't have a video, where they just have to rely on their memories. I think the cases where we are talking about overemphasis of one type of evidence, one piece of evidence over another, is when we're talking about evidence of a similar quality, like testimonial evidence.
I think I'm with you on this one. I wanted to make sure I understand the facts correctly. This video that we're talking about was made by baby's mom's sister, right?
That's correct.
She was in the birthing room at the time?
That's correct.
So the aunt. So the auntie's video was not allowed. It was used at trial, but not allowed unbridled in the jury room. Is that correct too?
That's correct. Yes, it was used by both.
And then
parties.
some of the arguments I think that were made in the defendant's brief were some of the case law talks about treatises and medical things. Do you consider those to be not a fair comparison?
I think that's not a fair comparison at all. This is a video. It was not prepared in anticipation of litigation. It's not cultivated by any expert or party. This is just what happened. It's just what happened. The defendants also argue that they try to compare. They say you have to rely on the experts because the experts are going to tell you, whether Mick Roberts was performed properly or not. I don't think that's a fair comparison. We're not trying to unduly emphasize any evidence here. We're just trying to give the jury access to what happened. They have to decide, make decisions about what happened and whether it was appropriate. And
I'm like Justice Christensen. I don't see what's the big deal about letting the jury have the DVD. But I have a question, which is, was there? Ms. Schiltz suggests that it was at least left open the possibility that the jury could see the video more or the DVD more than once if they requested.
I don't think that's what the record shows. I think the record shows that the defendants objected to the full video going back. There was argument, and that the plaintiffs argued that that was very prejudicial, especially in light of the fact that the defendants had these 10 screenshots that they hand-selected that were given to the jury. We had no opportunity to pick our favorite screenshots and send those back to the jury for consideration. We assumed that the birth video would go back. There was no motion in limine to exclude the birth video. It was admitted into evidence without objection, and I believe the judge ruled that the jury would have an opportunity if they asked to view the video once and only once, and that there was no legitimate justification for preventing the jury from viewing that evidence, especially in light of the fact that there was really conflicting testimony between the experts on the performance of Mick Roberts, for example. I mean, you're supposed to take those legs and you're supposed to hoist them back, and our expert testified that that didn't happen. And if you watch the video, you can see that, they're barely lifted up out of the stirrups, and the expert testified that was the defendant's experts, that was Mick Roberts, it was properly done. I think the jury should get to look at that and see what was done, and if not for evaluating whether it was done properly, the credibility of the experts, which is also something that the jury has to consider.
How long was the jury out?
Not very long. 3 hours, maybe, is my best recollection.
And how long is this video?
The video is long. The video might be 2 hours, but the birth section is maybe 1 minute or 10.
The video you wanted to go back, how long would they saw it once? I'm trying to figure out how much they deliberated after seeing that video. I mean, if they're out 3 hours, which is a real short time for a medical negligence case.
I assume, but I don't know, that they probably fast-forwarded to the actual birth. There's time where people are just sitting around in the room and nothing's really happening. And then there's a period of time which was emphasized by both parties and their experts during the testimony. I have to assume that they focused on that, but I don't know. I mean, they could have.
And how many days was the trial?
10-day trial.
Thank you.
Thank you for your time. We believe that the parties are in agreement that Tristan Derby did not receive a fair trial. The defendants in this case filed 3 motions for a mistrial, which were denied. Up until they received a jury verdict, they were in agreement that Tristan did not have a fair trial. There were several errors that did not allow the jury to properly consider the plaintiff's case, including not having access to the video and not having proper jury instructions to guide their deliberations. We believe that Tristan should be allowed a new trial based on one or more of these errors. Thank you very much.
Ms. Keller, thank you as well. Ms. Schiltz, thank you again. The case of Larry Eisenhauer versus Henry County Healthcare and others is now then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.